Hey everybody, Todd Seymour, and glad to be with you today to talk about what I feel is a very overlooked problem with some clients, and that's two essential legal documents that everybody should have. And by everybody, I mean regardless of your age, everybody should have these documents. And those two documents are a living will and a durable power of attorney. So we're going to talk about both of these things and give you maybe some examples and some suggestions that I have on why you should have these things as well. So everybody, for the most part, this was a nationwide case in Florida, should remember the Terri Schiavo case and how there was a battle between her parents and her husband when Terri was on artificial means of support. And it was a multi-year battle about having the judge relinquish the life support to let her pass away in peace. So many people, again, especially younger people, when we're young, we feel like we're just inevitable, that we're never going to die. And I hate to say it, I when I used to give seminars all the time, I would open up by saying, if you could just deal with the fact that you're going to die, then I can help you. And people would be like, I cannot believe that you just opened up a seminar like that. But it's true. I mean, the reason why I do what I do for a living and try to help so many people is because we are so lucky to be born. And I feel like if we can have all these different things lined up, whether it's saving for retirement and setting up estate documents and dealing with taxes and all the different kinds of aspects that deal with your financial life that nobody teaches you about, to me, it gives people comfort knowing that, man, if anything does happen to me down the road or unexpectedly, like it seems to, then I'm going to be good, my family's going to be good, and everything I worked my entire life for. And that's why these two documents can never be overlooked, especially with younger people or older people for that matter. So let's talk a little bit about the living will. That's pretty self-explanatory. Basically, the document says, if I become, in a vegetative state, or if I become to the point where I'm being supported by artificial means, I don't want that. So it basically takes the burden away from everybody. You've already given instruction on that. The durable power of attorney is a much more complicated document. And I'm going to go ahead and preference these two documents. I call them living documents. And the reason why I say that they're living documents is because when you pass away, both of these documents go away. And both of these documents are a state by state document. And what that means is that if I live in Florida, I need to have a Florida living will and a Florida durable power of attorney. And if I live in Illinois, I need to have an Illinois living will and an Illinois durable power of attorney. And if I'm a snowbird and I spend 6 months in Illinois and 6 months in Florida, I should technically have two living wills and two durable power of attorneys to cover each state, because both of them deal with their own statutes. And if you read these documents, it'll say, per Florida statute, 1, 2, so forth. So you got to make sure that those are done. The other thing is that they should be updated at least every 5 to 6 years. And why is that? Because statutes in states change. There's turnover every usually 4 to 5 years, and when that happens, the new rules are made and statutes change and documents need to be updated. And a lot of times when I worked for the law firm, people said, oh, they're just doing that so the lawyers can make more money, and that's not the case. I mean, attorneys just have to keep up with the rules. It's their jobs to protect you. So state by state documents, you need to have it according to your state. They should be updated at least every 5 to 6 years. I see things all the time where clients don't review these documents. It's very common that people do estate documents and then put it in a drawer and never review it again. And that's why I remind people every tax season that we should definitely review your estate docs to see if there's any changes at all. So a durable power of attorney is different than just a plain old power of attorney, because durable means that it can handle you if you become incapacitated. So in incapacitated, you have Alzheimer's or you get into a car accident, a durable power of attorney will let you handle that if that comes up. So that's the first thing. Second thing is that the power of attorney, again, it basically dies when you die. The most important thing is that you are letting that person. So I'm writing, you're letting your POA be you. And that's why that document is so important. So we talked about a trust before, where a trust is basically letting somebody take over your business when you pass away or become incapacitated. And so durable power of attorney is letting them be you. So they're not handling the business, they're handling that individual. So if my wife was my power of attorney, then if I become incapacitated, then she can take over and handle all my personal affairs, pay my bills, those kind of things, set up my doctor's appointments, talk to my doctor, because of having that durable power of attorney. The other thing is that, without a doubt, you should have a backup. And a lot of clients sometimes overlook the fact that you need to have a backup power of attorney. So while my wife is my power of attorney, in case something happens to her, I want what's called a contingent or a backup power of attorney. And that should always be the case on every type of beneficiary, every type of legal document. You always want to cover worst case scenarios. There's things that happen all the time, unfortunately, in life that you don't expect, that you need to make sure that you're covering all worst case scenarios. And sometimes when you look at your overall financial situation or your estate planning, that's my job. What we do with other clients is look at your situation and think, am I planned for worst case? If I am, then I'm good. Then I should have nothing to worry about. If anything worst case happens, then I've definitely planned for it. So some of the things in Florida, at least, that because you're letting that person be you, there's so many important factors that it covers. Usually power of attorneys are multiple pages, because it's basically having the attorney address all the different scenarios that you can cover. And in Florida, there's actually 4 pieces, let's call them, that you have to initial, because they're so important. Now, it's not like this in every state. Most durable power of attorneys, or every attorney or every power of attorney, says these 4 pieces, but most people, to be honest with you, when they had the initial, they never realized it was in there. And I'll give you a couple examples, and then a couple real life examples why they're in there. One of them says that you're going to let your durable power of attorney create a trust for you if need be. And I have some clients, when they're signing this, they'll say, why would my power of attorney ever need to create a trust for me? Well, I'll give you an example. So when I was at the law office, I used to work in the evenings all the time. And there was a gentleman there that would come in and he would clean up the office and things like that. And him and I were talking, and unfortunately his mom was living at home and in hospice care. And being the weird person that I am and doing this for so long, I said, hey, who owns that home that your mom lives in? And he said, my mom, it's in my mom's name. And I said, well, who has power of attorney of your mom? And he said, I do. And I said, we need to get that house out of your mom's name and into your mom's trust. And because you have power of attorney, you can create a trust on her behalf, and we can do what's called a quitclaim deed, which is taking it out of mom's name and putting it into mom's name as trustee. And we did that, and unfortunately mom passed away about 4 days later. But for the gentleman, there was no probate that he had to go through, or his siblings, because we were able to take it out of mom's name and put it into the trust. The house was worth around $200,000. In Florida, probate is 3%, so that's $6,000 in probate fees that we saved just because he was able to use his durable power of attorney. And it's like, many times when you're talking to people, you have to remind them that, again, you're planning for the unexpected. You would never think that that would come into play or that you'd be able to use that. I've actually seen where I'm meeting with clients and they have a durable power of attorney, and the 4 pieces, the client never initialed that. So they're not giving that power of attorney that leeway, that flexibility, those rights that they should be able to take over. And they said that they were advised by other people not to. So here's my opinion. Again, I'm not trying to lead you one way or another, but those 4 pieces that you have to initial, the creating of trust for your power of attorney, creating, changing beneficiaries if you need to. Sometimes you need to change beneficiaries for estate planning purposes. There's a multitude of things, again, that's in that durable power of attorney, and they've always been in that durable power of attorney forever. It's just that recently, within the past 5-6 years, the state of Florida pulled them out and makes you initial it now. And my opinion is, why would you let somebody be your power of attorney if you didn't trust them? So either you trust them all the way or you don't trust them enough. I don't want to be a power of attorney and have one arm tied behind my back. I want to be able to do what's best for the person that, so for my wife, I want to be able to do whatever I need to do to take care of paying the bills and doing things. For her, it's the same. And for clients, it should be the same, whether it's your spouse or your children being your power of attorney and so forth. So some things to think about between these 2 documents. Absolute must. They're relatively inexpensive. They're good for at least 5 or 6 years. It goes back to the don't be penny wise, pound foolish. These documents, especially in, unfortunately, today's world, I say when I started doing this 27 years ago, I had 1 client that had Alzheimer's. And today I think I have 25% of my clients have Alzheimer's. It's amazing to me that these things creep up. Life changes so unexpectedly. But if we're planned for it, then we can deal with it. So I'd love to hear your feedback, as always, at taxandtrusthelp@gmail.com. Thank you again so much. I truly appreciate you and hope you learned a little bit enough on these 2 documents just to make you dangerous. Thank you.